We'll read out the last two paragraphs only. It is the union's own stand that the commissioner had adjudicated all claims to the procedure established by law, where the possibility of appeal was provided. Further, it has been admitted in the proceedings culminating in the court's order dated 19/7/2004 that the amount of settlement was found to be in surplus of the actual requirement, and thus the claimants had been, quote, provided compensation that was more than what was reasonably awarded to them under the law. This reinforces the position that the settlement amount was sufficient to compensate the claimants. The union has filed the present curative petition seeking to reopen the settlement. After opposing attempts by private parties to do so, the scenario arising in the case of a shortage was clearly outlined in review judgment. The responsibility was placed on the Union of India, being a welfare state, to make good the deficiency and to take out the relevant insurance policy. Surprisingly, we are informed that no such insurance policy was taken out. This is gross negligence on part of the Union of India and is in breach of the directions made in the review judgment. The Union cannot be negligent on this aspect and then seek a prayer from this court to fix such responsibility on the UCC. Union of India claims for a top-up has no foundation in any known legal principle. Either a settlement is valid or it is to be set aside in cases where it is vitiated by fraud. No such fraud has been pleaded by the Union of India, and their only contention relates to a number of victims, injuries, and costs that were not contemplated at the time the settlement was effected. This is also specifically no pleadings under the heading of claims 2 and 3 that can be said to be admissible, or one that cannot be envisaged at the stage of settlement. It was known that medical facilities would have to be extended to rehabilitate people, and there was bound to be environmental degradations. In fact, it is the UCC's allegation that union and state government did not proactively detoxify or decommission the site, thereby aggravating the problem. In any case, this cannot be a ground to seek annulment of the compromise, particularly as the settlement has to be reached in an expedient manner. The learned Attorney General's response has been that the method of topping up the settlement amounts to be revised under Article 142 of the Constitution of India. We believe this would not be the appropriate course of action or method to impose a greater liability on the UCC than it initially agreed to bear. We are equally dissatisfied with the Union of India being unable to furnish any rationale for taking up this issue more than 2 decades after the incident. Even assuming that the figures of affected persons turned out to be larger than contemplated earlier, an excess amount of funds remain available to satisfy such claims. The Welfare Commissioner has in fact held in the order dated 31/1/2009 that on including the pro rata compensation, nearly 6 times the amount of compensation has been disbursed to the victims in comparison with motor vehicle accident claims. This order came in an application filed by the organizations who sought enhancement of their claim amounts due to fluctuations in conversion value of dollar vis-a-vis the rupee prevailing at the time of the in 1989. A sum of rupees 50 crore lying with RBI shall be utilized by Union of India to satisfy pending claims, if any, in accordance with the Bhopal Gas Leak Disaster Act 1985, the scheme framed thereunder. Providing closure to the list is also a very important aspect. This is more so in the context of scenario faced by the Indian judiciary, where delay is almost inevitable. This concern would be further amplified in respect of tort claims such as the present one. Evidence were to be led for claimants. This would open a Pandora's box in UCC's favor and would only be to the detriment of the beneficiaries. Money was needed to be immediate aftermath of the tragedy and not after 3 decades. Thus, the finality was reached at an earlier stage by way of settlement. Endeavor to reopen the same proved unsuccessful. Now, the curative petitions have been filed by the Union of India, having not filed a review petition. Private parties who are here before us seek to ride on the coattails of the Union. This is not something we can follow. We are thus of the view that for all the curative petitions cannot be entertained, and we thus dismiss it, leaving the parties to bear their own costs. It's a single order on behalf of all the honorable tribunals.
My lords,